Subscribe to both of my YouTube channels, Sharron WINBUSH and Goddess Sharron. Turn on notifications and share all videos globally. Thank you. This is the Rule 33 motion to ask for a new trial based on ineffective counsel. There are two parts. Part one is based on not conducting a sufficient voir dire, and part two is based on not having conflict-free counsel, which was a violation of Robert Kelly's Sixth Amendment constitutional right to have effective counsel and the counsel of his choice. So in the part one of the Rule 33 for United States versus Robert Kelly, filed by Jennifer BONJEAN, February 17th, 2022. The introduction states, "It is axiomatic that a defendant is entitled to the effective assistance of counsel. U.S. Constitution Amendment 6, incorporated in defendant's Sixth Amendment right guarantee, is the right to conflict-free counsel. Defendant was denied his Sixth Amendment guarantees in a number of ways, some of which are clear from the record and some of which are not. In this complex RICO prosecution, defendant's legal team fell apart mere weeks before the commencement of trial. The docket reflects that defendant's lawyers were unable to effectively represent defendant. Energy, resources, and time that should have been devoted to preparing for trial were expended battling each other until two of defendant's more experienced attorneys were granted leave to withdraw. Defendant was left with a disjointed, unprepared trial team and no singular defense strategy. This motion identifies two serious violations of defendant's Sixth Amendment constitutional guarantees that require a new trial and are apparent from the record. Specifically, defendant is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on this jury. Defendant was also denied conflict-free counsel where his attorney, Ms. Becker, simultaneously represented one of the government's key witnesses. These violations of defendant's Sixth Amendment rights are so serious as to demand a new trial without showing of prejudice. Legal standard. Federal Rule of Criminal Procedure 33 provides that upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interests of justice so requires. Unlike Rule 29, Rule 33 confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice, but such discretion should be exercised sparingly. Argument. Number one, the defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R. Kelly, or were familiar with prior accusations of sexual abuse of minors against defendant. Counsel's objectively unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial. As United States Supreme Court Justice Black stated, it is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effects of such occurrences when they happen. The right to a jury trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true regardless of the heinousness of the crime charged, the apparent guilty of the offender, or the station in life which he occupied. A juror who has formed an opinion cannot be impartial. Internal citations omitted. Rule 24 of the Federal Rules of Criminal Procedure governs voir dire in criminal trials. The rule provides that if the court examines jurors, it must permit the attorney for the parties to A, ask further questions that the court considers proper, or B, submit further questions that the court may ask if it considers them proper. A trial judge who under Rule 24 decides to examine prospective jurors himself must at the very least solicit questions from both parties' attorneys. Naturally, the trial court's duty to ensure that each and every juror is fair and impartial is heightened, whereas here, pretrial publicity has greatly increased the odds that a potential juror has preconceived views of the accused's guilt. In a case of substantial pretrial publicity, jurors' subjective assessments of their own impartiality may not adequately screen for the possibility of prejudice. In an effort to protect defendants' cherished guarantee of a fair and impartial jury trial, this court implemented a procedure whereby potential jurors were asked to complete questionnaires that probed whether they had prior knowledge, preconceived notion, or biases about defendant given the unprecedented pretrial publicity he faced. Indeed, the questionnaire contained an entire section entitled Knowledge of the Case and People that asked jurors to reveal whether they had read, seen, or heard anything about the case that alleged crimes or people involved, and to describe in detail any information that they had previously learned by the defendant. The questionnaire expressly asked prospective jurors whether they had watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him. The court invited counsel for the government and the defendant to review the questionnaires in advance of jury selection and determine whether they could agree that certain individuals should be excluded for cause. The parties conducted that process and identified a set of potential jurors for the voir dire process. Inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on defendant's jury, who were clearly unqualified to serve on account of their preconceived beliefs about the defendant's guilt. These decisions cannot be justified by trial strategy, where the record fails to reflect that trial counsel conducted a sufficient inquiry to probe these jurors' biases. Indeed, trial counsel was mostly silent through voir dire. Although the court was responsible for questioning prospective jurors, it afforded the parties the opportunity to weigh in the questioning of prospective jurors who had made representations in their questionnaires that raised red flags. These questionnaires were highly effective tools for putting the parties on notice of jurors who might not be qualified to serve. But trial counsel made no effort to drill down on troubling representations that deemed further inquiry to ensure that the juror could be fair and impartial, regardless of any general assurances he or she provided to follow the court's instruction. Perhaps most troubling, most of the defendant's jurors were aware of prior allegations of sexual abuse against him, and several seated jurors had actually seen a scathing one-sided docuseries entitled Surviving R. Kelly that portrayed the defendant as a serial predator and included interviews with many of the government's witnesses, albeit outside the adversarial process. Defendant's jury should not have included a single person who saw the documentary Surviving R. Kelly. It defies all logic that a juror could possibly remain indifferent and consider only the evidence heard from the witness stand after watching this docuseries. But this court could not make cause challenges for defendant, nor do the defense counsel's job for it, although it tried at points. So she's saying the court didn't have the authority to make the challenges or do the defense team's job for them, but the judge did try. It was defense counsel's responsibility to conduct a meaningful voir dire, particularly in this high-publicized case, to ensure that the defendant's jury was fair and impartial. Trial counsel failed in its duty. For example, juror number 3 provided the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? I watched the documentary, but I forgot the name of it. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Yes, an entertainer. I heard that he has been sleeping with underage girls. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Yes. What were your general impressions? I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Do you know anything about the Me Too movement? Yes. It's a movement that seeks justice for rape victims 25 to 30 years after the fact. Trial counsel did not ask the court to question the juror any further about his responses to these questions, or to determine whether the juror could truly serve as impartial and unbiased juror in light of having seen the salacious and highly prejudicial docuseries. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about the defendant prior to legal issues or his reputation for sleeping with underage girls. Frankly, anyone who had seen the docuseries should have been automatically removed for cause. Juror number 4, revealed in the questionnaire. The charge in this case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as a fair and impartial juror? Yes, I find transmission of STDs in a non-consensual act to be particularly repulsive. Have you ever known anyone, including yourself, who was the victim of a sexual assault, other assault, or homicide, or any act of violence that required medical treatment or counseling? Yes, a close friend received asylum due to sexual assault and infection with HIV from the police in a foreign country. Which publicly known person do you least admire? Jeffrey Epstein. Although the court generally asked whether anything the juror read could affect his or her ability to be fair and impartial in the case, and the juror replied, "Not that I know of," but trial counsel did not ask the court to question the juror whether his feelings of repulsion about the transmission of STDs in a non-consensual scenario would interfere with his ability to serve as fair and impartial juror. No conceivable reason exists for failing to inquire further about the juror's feelings about the transmission of STDs in non-consensual circumstances, where the government charged defendant with precisely that act. Incredibly, this juror willingly disclosed that publicly known person he least admires is Jeffrey Epstein, an accused pedophile, just like the defendant, with no meaningful inquiry about whether this juror could truly serve as a fair and impartial juror. The juror was seated. Juror number 5 disclosed the following in his or her questionnaire. Have you watched or heard any interview of Robert Kelly, any TV shows featuring him, any specials or documentaries? Yes. What were your general impression? He loves underage girls. From what you have seen or heard, do you have general impressions of the defendant? Somewhat negative. Why do you feel that way? The allegations related, he was sleeping with underage girls. Although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when asked if he or she could be fair, the juror indicated that he or she would give it a shot. The court reminded the juror that he or she had to be certain that she would consider only evidence offered at trial, and the juror acquiesced. Incredibly, the court seemed very concerned about this juror's ability to be fair, observing, "So I don't know about you, but when someone says they think they can do something in this context, I don't think that's an unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we still ended up with, I think so. So let me hear from the government if you have a position on that." Not surprisingly, the government was confident that the juror indicated she could be fair. The court still expressed doubts. Inexplicably, trial counsel, which is Robert's lawyer, which was Deveraux CANNICK, agreed with the government, and the juror was seated. To be blunt, defense counsel agreed to the seating of a juror who not only watched Surviving R. Kelly, but concluded that defendant loves underage girls. There simply cannot be any trial strategy for failing to excuse this juror for cause. Had trial counsel challenged this clearly unqualified juror, the court seemingly would have struck him or her from the case. Trial counsel not only didn't move to disqualify the juror, he didn't even ask the court to probe. The fact that she states he, that tells you it was a male lawyer, and Deveraux CANNICK was the one in charge of the case at this time. More deeply into the juror's statements on the questionnaire, the defendant loves underage girls. Juror number 7 also revealed in his questionnaire that he had heard about the case and the alleged crimes. Trial counsel did not ask the court to question the juror any further about what he heard specifically or where he heard it. The court merely asked the juror whether he could put aside what he heard and rely on the evidence presented in the case. Juror number 8 also disclosed that he or she had heard about crimes defendant is alleged to have committed, and further indicated that he or she believed that the allegations related to another case in another state. Again, trial counsel failed to probe what precisely the prospective juror had heard or conduct a meaningful inquiry into whether she could be fair given what she had heard. So when they say she, they're referring that this juror was female. Juror number 9 also indicated that she knew the defendant had issues with the law, but could not say exact for what. She, the juror, also described the Me Too movement as the power structure of a male-dominated industry had been turned on its head. Again, trial counsel did not ask the court to question this juror about any details she may have heard about the defendant's issues with the law, nor did he, she's indicating the lawyer was a he, that was Deveraux CANNICK, nor did CANNICK ask the court to inquire about the defendant's views concerning the Me Too movement and the role in changing power dynamics in the male-dominated movie industry. Juror number 11 similarly disclosed that he or she saw the case mentioned on the news when he was first being investigated, and that she had read or seen that he had allegations of misconduct lodged against him. Shockingly, Trial counsel, Deveraux CANNICK, did not ask the court to follow up on any of these important revelations to determine whether this juror was qualified. Juror number 12 offered several concerning answers in response to the questionnaire. Question: have you read, seen, or heard anything about the case, the alleged crimes, or the people involved? Yes. Describe in detail what you recall reading, seeing, or hearing about. Answer: sex with minors, specific details do not come to mind. Parodies on TV regarding details of defendant's personal life. SNL, Dave Chappelle was in jail prior, then released. Have you read, seen, or heard about RKELLY? Yes, same answer as above. Various instances of achievement in musical career, songs on the radio, videos, entertainment, news shows. Specifics are not remembered. From what you have seen, read, or heard, do you have a general impression of the defendant? Somewhat negative. Why? I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotional one, impacted by the nature of the charges against him. Do you know anything about the Me Too movement? Entertainment industry-led movement encouraging women to come forward and name their accusers. Associated it with accuser Harvey Weinstein, various news articles, and TV segments. Trial counsel, Deveraux CANNICK, questioned the juror about his or her ability to be fair and obtained assurances from the juror that he or she could, but trial counsel did not bother to ask the court to inquire about the juror's reference to defendant's personal life, sex with minors, or Dave Chappelle's SNL skit, which referenced prior allegations against the defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. It is beyond comprehension that trial counsel Deveraux CANNICK would not have sought to inquire further of this juror about his prior knowledge about allegations against defendant or press whether he could truly be fair given the information with which he came to the jury. Nearly all the alternative jurors admitted that they were aware of allegations of sexual abuse against defendant. In fact, one of the alternative jurors stated, "No, there have been accusations related to this for quite some time. Think defendant was married to Aaliyah, who was underage at the time." And further admitted she had seen defendant's interview with Gayle King in which he stood up and yelled to defend himself. Although defense counsel indicated that he, CANNICK, intended to challenge this alternate for cause, no motion was formally made and the alternate remained on the jury. Critically, alternate juror number 4 revealed that she was aware that defendant was married to Aaliyah when she was young, but claimed that she had not really heard much about the case and assured the court she could be fair. Again, trial counsel had no follow-up questions for this alternate juror. Notably, this juror apparently was familiar with well-known Me Too lawyer Gloria Allred, who represented some of the government's witnesses and asked if she could get Allred's autograph in the middle of trial. Defendant had no chance to defend himself, where most of the jurors in this case were fully aware of his prior legal issues. Some had watched the damning docuseries Surviving R. Kelly, and many seemed to accept that he was known for abusing minors. Frankly, everyone in the courtroom seemed to accept that defendant's jury would be prejudiced against him and made virtually no effort to impanel a truly unbiased jury. That's a hell of a statement. The judge, the trial team, the prosecution, everyone in the courtroom just seemed to accept the fact that Robert's jury was prejudiced against him, and no one made an effort to impanel an unbiased jury. Although the court generally asked jurors about their ability to be fair, it was counsel's job, Deveraux CANNICK as lead counsel, to elicit as much information as possible to determine whether the juror could actually be fair. As stated previously, in a case of substantial pretrial publicity, jurors' subjective assessments of their own impartiality may not adequately screen for the possibility of prejudice. Voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial jury will be honored. As early as 1895, the Supreme Court in Connors v. the United States explained that an adequate voir dire is essential to ensure that prospective jurors will be free of bias or prejudice and will perform their duties impartially. The primary purpose of the voir dire is to make possible the impaneling of a jury through questions that permit the intelligent exercise of challenges by counsel. Defendant received ineffective assistance of counsel where his trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure that they were free of bias or prejudice. Counsel also failed to challenge jurors who were clearly disqualified from serving, including those who had seen the highly prejudicial documentary Surviving R. Kelly. To prevail on a claim of ineffective assistance of counsel, a defendant must demonstrate both that his attorney's representation was unreasonable under the prevailing professional norms and that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceedings would have been different. Trial counsel's performance was unreasonable under prevailing professional norms, where he, Deveraux CANNICK, failed to question clearly biased jurors about the extent of their knowledge about defendants' prior legal issues, allegations of sexual abuse, and their feelings about the documentary Surviving R. Kelly. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise the defendant's preemptory challenges without properly questioning potential jurors to learn of potential biases. In this case, numerous jurors divulged that they had prior biases from having learned information about the defendant through other sources prior to the jury selection process. Their own subjective assurances that they could be fair was not sufficient to ensure that they did not harbor beliefs, preconceived ideas about the defendant's guilt. Significantly, one alternate juror saw Me Too lawyer Gloria Allred in the courtroom. Allred represented a few of the government's witnesses and was a common fixture on all media platforms, declaring the defendant was the worst predator she had ever pursued. During the middle of trial, the juror asked the courtroom deputy if she could obtain an autograph from Allred. When asked by the court why she wanted the autograph, the juror responded, "Because I admire her. Just 'cause, other cases I've never heard, I didn't know she was going to be here. I just admire her for what she's accomplished." This was the same alternate juror who admitted during the jury selection process that she knew about allegations against the defendant and specifically that he was married to Aaliyah when she was underage. Trial counsel Deveraux CANNICK belatedly sought to remove the juror after the fact, stating, "I can't think of anything more disqualifying than a juror asking for the autograph of one of the attorneys who represents one of the witnesses. It speaks to a bias for the prosecution's witness, and for that reason I would ask that she be removed." That request was denied. Trial counsel was, of course, concerned that this juror clearly evinced a bias against defendant and in favor of his accusers. But counsel's failure to ask the court to question the juror during voir dire more extensively about her factual knowledge of the defendant's marriage to Aaliyah and her feelings concerning allegations of sexual abuse made it impossible for the defendant to gather an accurate impression and make an educated decision about whether she was qualified to serve. Had counsel competently questioned this juror, he, Deveraux CANNICK, likely would have learned information that revealed a bias consistent with her request to obtain an autograph from Allred, a woman she admired, who called defendant the worst predator she has pursued. Defendant has demonstrated prejudice by trial counsel's failure to conduct any meaningful voir dire where his jury was comprised largely of people who were seated with an understanding that the defendant was a sexual predator. Because defendant cannot possibly prove the likelihood of success if his case was heard by a fair and impartial jury, prejudice must be presumed. Trial counsel abdicated all responsibility to conduct a meaningful voir dire, which resulted in a jury that was largely unqualified to serve. The United States Supreme Court has recognized that in certain Sixth Amendment contexts, prejudice is presumed, actual or constructive. Denial of the assistance of counsel altogether is legally presumed to result in prejudice. This case is one of those rare cases. Accordingly, this court should vacate the verdicts of guilt and grant defendant a new trial. The Mute R. Kelly campaign stopped the flow of R. Kelly's income. Sony releasing him hemorrhaged him financially. His inability to tour. He had back taxes because of poor management and accounting that the government seized assets for that. And then he had back child support. He's been not in a position to hire the top-notch legal team necessary to get through this entire case, which is why he was compromised in the New York case. He needs all his fans, supporters, or anyone who wants to help to send money directly to him, not through a third party, because he has an upcoming Chicago case and he must have great legal representation to defend himself to the best of his ability. Mr. Kelly is fighting a case in Chicago and he needs all of the assistance that anyone can give from all of his fans and supporters around the world. There are 3 ways that you can get money to Mr. Kelly. 1, you can send money via Western Union. That's for $300 or less. That will get to him fast. Or you can go to the BOP.gov website and send money via credit card. Those are the fastest ways to get it to him. Or you can mail a money order to him to P.O. Box 474701, Des Moines, Iowa, 50947-0001. It will go directly to Mr. Kelly, no third party, no one in between, and he will have a record of who sent what amount, and from where it was sent. So it is your way to directly help, directly impact, to directly put your hands on R. Kelly and show him that you love him, show that his fans from around the world are supporting him and they want to assist him in fighting for his freedom.